All right. Hello, hello. It has been a very eventful day today. Sorry, trying to fix myself. Lyric Armstrong here, your real estate agent and advocate. We were on this noon time on the West Coast, 3 o'clock time on the East Coast, and we tried to watch the hearing. We have now the hearing. Thank you to the trial channel. Yay! Thank you to the trial channel. Didn't know how long it was going to take. Didn't know what in the world we had to do to get it to happen. But I was in the stream and I said, I know that the trial channel is going to have it. And they do. They must have so big ups to the trial channel. They really must have the inside source. Let's go in court. It's about time that we got to see the June 22nd hearing. I know that there were some reports as to what transpired. Let's find out for ourselves how accurate that is. Welcome, welcome, welcome. Hit the like button. Make sure that you're subscribed to this channel because we are live. And finally, the O'Keefe versus Reed hearing motion to compel regarding Colin Albert.
83 CV 00692, Paul O'Keefe, individually and personal representative of the estate.
Behalf of non-party witness Colin Albert, I'd like to.
That is our first aha. It's Christopher, not Kieran. And Christopher is not pro hoc vice either. So, okay.
Thank the court for its consideration of allowing me to participate today, even though I'm pro hoc in on the defamation case and not on this one.
No problems, without objection, correct?
Correct.
Okay.
Yeah.
So
objection.
does the email you sent this morning, Attorney Rosenberg, to the clerk reflect the present status of the parties?
Yes, Your Honor.
Okay. And with respect to, you basically have two categories that are the subject of discussion, correct? The communications with the deponent's parents would be one category, and then the other one would be communications with others.
Yeah, that's not exactly how we'd been discussing it last, but I see how you're saying that. Yeah.
Okay. And then in the email to Attorney Maddie today, or I don't know when it was, I guess it was on Friday.
Yeah, Friday, I think.
You reference a date range of January 28th, 2022 through December 31st, 2023. What category does that relate to?
So it would relate to both in part. So as you know, we originally had.
Just tell me.
Well, it would relate to for the non-parent category. Start with that. It would relate entirely to that.
Okay.
And then for the parents, there are two separate proposals we made. One was
A and B in the email.
Correct. So it would apply to B in that email as well. So it would apply to everyone.
Okay. And then
Hi, there is Dr. Chad Walding, co-founder of Native Path. We look at collagen differently than other supplements.
I keep forgetting to fix that.
are the communications that you talked about, the period of January 28th, 2022 through April 30th, 2022, which were a subset of the parent ones.
Correct.
Are those limited by the which relate to language?
No, and there was a reason for that. So obviously one of the disputed issues, as you can see in the papers, is Mr. Albert's timing for being at and then departing 34 Fairview. We believe that we're entitled to discovery that encompasses communications around that fact, and there could be, and I would imagine would be communications in the immediate or close to immediate days or months after an event like this between close family members that would reflect those movements and would be relevant to those movements. However, we recognize that asking for every communication between a parent and their son can't be years. It can't even be the year, 2 years that we've limited ourselves to. So what we're trying to do is have a much smaller scope where we request all communications. Obviously, if there's attorney-client privilege or something like that, that is, they can make that claim. But we're requesting all communications within a very small period of time, and then the parents would be lumped back in with everyone else for the remainder of the period through December 31st, 2023.
And that small period of time is what?
Our last proposal was January 28th, 2022 through April 30th, 2022.
Reed has claimed
That,
is a false narrative
oh my
surrounding
gosh. So, okay, nice try, counselor. Like, I don't. We'll see where the judge lands on this. But no one is looking for Colin to tell us what the discovery and what the investigation was on the case. He was barely an adult. Like, what was he, like 19, 20? So he was 20 at trial, and that was 2 years ago. This happened in 2022. So he was like 18. He was 17 years old, I think was his actual age during the time of John O'Keefe's death. So no, sir, we're not interested at all in Colin Albert testifying to how the investigation was handled. He doesn't know that.
I'm sorry, what the plaintiff would claim is her false narrative surrounding that death. So
time scope, we cut it more than in half. We address the terms, but at a certain point.
may I respond briefly, Your Honor?
Absolutely.
So on the false narrative claim,
So
what Ms. Reed apparently wants to
Oh my
present as a
goodness, you
defense
guys can't
in the
hear?
case to the emotional distress counts is that what she said was in fact true.
Oh, that's great. Oh my gosh. I'm so sorry. This was so good. Okay, we'll take it back. Look, we got time, right? We'll take it back. We'll speed it up just a little to get through the next thing.
Parties.
Yes, Your Honor.
I thought you could hear.
And with respect to, I mean, you basically have two categories that are the subject of discussion, correct? The
So insane.
communications with the deponent's parents would be one category, and then the other one would be communications with others.
Yeah, that's not exactly how we've been discussing it last, but I see how you're saying that. Yeah.
Okay. And then in the email to Attorney Maddie today, or I don't know when it was, I guess it was on Friday.
Yeah, Friday.
You reference a date range of January 28th, 2022 through December 31st, 2023. What category does that relate to?
So it would relate to both in part. So as you know, we originally had.
Just tell me.
Well, it would relate to for the non-parent category. Start with that. It would relate entirely to that.
Okay.
And then for the parents, there are two separate proposals we made. One was
A and B in the email.
correct. So it would apply to B in that email as well. So it would apply to everyone.
Okay. And then are the communications that you talked about the period of January 28th, 2022 through April 30th, 2022, which were a subset of the parent ones,
Correct.
are those limited by the which relate to language?
No, and there was a reason for that. So obviously one of the disputed issues, as you can see in the papers, is Mr. Albert's timing for being at and then departing 34 Fairview. We believe that we're entitled to discovery that encompasses communications around that fact, and there could be, and I would imagine would be, communications in the immediate or close to immediate days or months after an event like this between close family members that would reflect those movements and would be relevant to those movements. However, we recognize that asking for every communication between a parent and their son can't be years. It can't even be the year, 2 years that we've limited ourselves to. So what we're trying to do is have a much smaller scope where we request all communications. Obviously, if there's attorney-client privilege or something like that, that is, they can make that claim. But we're requesting all communications within a very small period of time, and then the parents would be lumped back in with everyone else for the remainder of the period through December 31st, 2023.
And that small period of time is what?
Our last proposal was January 28th, 2022 through April 30th, 2022.
And why do you suggest it should not be limited to the issues otherwise identified?
Because let's just take, for example, that there's a communication about when you got picked up. That wouldn't relate necessarily to the categories that we have listed here, right? The death of Mr. O'Keefe, the investigation to Mr. O'Keefe, I would say it's relevant, obviously, but you could see communications about timing, who was driving, how they knew to go pick you up, et cetera. I'm just giving you examples now, but things that would not otherwise fall within that category. And we're not asking for that with everyone, but we are asking for it as between Colin and his parents.
You don't believe there's any way to limit the scope of that request to other than all?
We could try to limit it to, say,
I take it if you haven't communicated since Friday afternoon, you haven't been trying, right?
well, as you saw in the communication, I haven't been trying, correct, because I made a final proposal on Friday that you just referred to, and the response I got was we're comfortable with our last proposal.
Let me hear.
Yes, Your Honor, and I'm maybe at a bit of a disadvantage because I don't believe I was copied on the email correspondence this morning. And if I wasn't, if I was, please correct me, Attorney Rosenberg.
Wait, how could you be copied? You weren't on the case there, bud.
But I don't think I was copied on.
Yeah, that's my fault. Your co-counsel was. I apologize.
I'll tell you what, it'd be helpful if you went and familiarize yourself with it. So why don't we get a copy?
Yeah, here you go.
Right? Take a short break. You don't have to read it in front of everyone.
Right.
Take a short break and let you read that so you're up to speed like everyone else.
Read for the class.
All right.
Let me tell you.
Okay, so we're taking a short break. Let's have nothing to do with that. It's just one of them days. All right, let's get past the break and get back on the record in just a second. It's been quite an eventful day, has it not? Okay, let's see. I think the trial channel has us all squared away. Thank you, trial channel. Thanks so much. We now have the hearing. Okay, is this the right one? Now I don't know which one's the right one. Hold on, let me make sure I get the right. 618. Let's see. Hopefully this is right. Okay, looks like we're good now.
I get your honor, yes. It was just a transmittal email that included the rest of our correspondence, so I'm comfortable with that.
Okay, so what do you say to whether or not the scope of the request for that limited time period could be reduced from everything to something less?
Yes, Your Honor. Our proposal, which we made to defense counsel, we thought was quite broad and actually should capture information concerning, for example, Mr. Albert's movements on January 28th. What we suggested was that.
Well, they didn't take it that way, I guess, right?
Well, they may not have, but what we suggested, and perhaps the court, you can tell me if you think this is fairly broad in scope, but what we've suggested is.
Right now, it doesn't matter what I think. What matters is what the two of you think, and what you can agree to.
Yeah. So our belief is that anything that Mr. Albert may have, any communications or documents that he may have relating to the facts and circumstances of Mr. O'Keefe's death, or the law enforcement investigation into Mr. O'Keefe's death, will encompass any responsive material that would be relevant to this matter. And we're willing to do that. We're willing to do that for a 3.5-year period, and we're willing to do it with respect to every individual that they've asked for communications to or from. And so this, to me, is a little bit of a situation where Ms. Reed won't take yes for an answer. We're actually agreeing to provide anything that we may have relating to the facts of John O'Keefe's death, which is essentially in this case, or the investigation into his death, which, as I understand it, would encompass what Ms. Reed has claimed is a false narrative surrounding. What the plaintiff would claim is her false narrative surrounding that death. So we are comfortable that frankly, that we've kind of bent over backwards to include a 3.5-year time period of two very broad categories. I offered to discuss search terms with counsel that we could agree to in order to come up with materials that might be responsive. And so, for example, if counsel felt that the category we've suggested would not encompass the timing of when Mr. Albert left 34 Fairview, the way around that is just to agree to a search term that would capture those communications, because we have no objection that those would be responsive and within the category we suggested. But what we object to is a unscoped request for materials, particularly relating to communications he may have had with his parents, and the very, very broad categories that seem designed to capture information that is not relevant to the issues in this case, which, as I understand it, are one, the facts and circumstances surrounding Officer O'Keefe's death.
Hang on.
Yep.
Give him a chance to respond.
Yes, sir.
Yeah, I'm actually going to address what I think Mr. Maddie was about to address. This case isn't just about what happened to John O'Keefe. It is, that's part of the wrongful death claims that the plaintiffs have alleged. But as your Honor is aware, they have these false narrative, intentional infliction of emotional distress, and negligent infliction claims, which relate to, as they call it, the false narrative. That includes the investigators, the investigation, and what Ms. Reed said in both her criminal trial and her other statements, that something happened to Mr. O'Keefe within the house. That is the false narrative. So it can't be limited to just the death of John O'Keefe. I'll give you one example. If Colin Albert had sent a text about Karen Reed, but not about the death of John O'Keefe and specifically the circumstances, I believe that's well within the scope of discovery in this case, and it would be excluded by what Mr. Albert's counsel has proposed. Similarly, if Mr. Albert said something about his relationship with investigators, which is a main part of that quote-unquote false narrative in this case, and that Mr. Albert himself is suing Ms. Reed about, that necessarily wouldn't have been included. So it needs to be broader. I'm more than happy to work on search terms with Mr. Albert's counsel. Efficient way to do that, but we need to either agree on, which we haven't been able to, or establish through your Honor what the scope and the categories that are rightfully at play here are, and then I'm more than happy to work with them on search terms immediately to get to those categories. But I think you hear that we've still got differences here, and this is not unscoped. You can see we proposed terms, we limited it from the subpoena. There are specific topics that we're asking for, not even of everyone, but only of certain individuals, and those topics are Ms. Reed, Mr. O'Keefe, the investigation, the state police and Canton police, the Norfolk DA, and the U.S. Attorney or DOJ. That's not everything under the sun. And to the extent there are categories or individuals where Mr. Albert has none, as I've said repeatedly, we will accept that. If counsel represents there were no documents as to, individuals A through D, then we're done with those. And additionally, if there was some extreme burden, right, there was one term or subject matter that was bringing back thousands of messages and it was going to be burdensome in order to go through and produce those, we would have considered that. But we haven't heard any of that in the communications or in the multiple hearings we've now had. It's just this overall, this is too broad. And we heard, Your Honor, about the time scope. We cut it more than in half. We addressed the terms, but at a certain point, we're entitled to the discovery that we're seeking pursuant to our.
Exactly. We hear nothing except for what's going on in the hearing, but not when they have their meet and confer moments.
May I respond briefly, Your Honor?
Absolutely.
So on the false narrative claim, what Ms. Reed apparently wants to present as a defense in the wrongful death case to the emotional distress counts is that what she said was in fact true. Happened inside the house, to the extent there's any evidence at all that she is at that point going to present to this court, then that would be captured by precisely what we've proposed, the circumstances surrounding John O'Keefe's death. So let's just take a parallel universe where Mr. O'Keefe, as Ms. Reed alleges, went into the house and something happened there. If Mr. Albert has any documents relating to that parallel universe, it would be captured by exactly what we proposed. Because what we are proposing to do is to provide any documents, any communications concerning the circumstances surrounding John O'Keefe's death. So that's number one. With respect to their claim that they should be entitled to any communication about Ms. Reed, Mr. Albert was and is a victim in a criminal case that's been brought against Aiden Kearney. That, as I understand it, Ms. Reed was at one subject of as well.
Hold on. Not even. So he is a victim. A victim of what, counselor? What is he a victim of? He is a non-party in this case, but he's a party in the other one. What victim is he?
She was not charged, but I'm highlighting this as an example of why Mr. Albert might very well have communicated she was brought against Aiden Kearney. That, as I understand it, Ms. Reed was at one point a subject of as well. She was not charged, but I'm highlighting this as an example of why Mr. Albert might very well have communications about Ms. Reed that have nothing to do with the issues in this case. They would want us to produce a communication in which Mr. Albert pointed out that Ms. Reed had a dog or a cat, which has no relevance to this case, or that Ms. Reed had launched a defamation campaign against him, which also has no relevance to this case. It may have relevance to some other case, but it has no relevance to whether or not Mr. O'Keefe, the circumstances surrounding his death, which again, we agree. Anything relating to that, they should get. Anything relating to the false narrative claim, which again has to do with the circumstances surrounding John O'Keefe's death, they should get. We've agreed to give that to him for a 3.5 year period. So I'm not understanding yet why the very, very broad scope, which I think counsel would acknowledge, would necessarily result in communications that are not relevant to anything here. Why the court should bless something like that when what we proposed, I think, broadly encompasses all of the claims in this case.
Just 2 quick points. One, the false narrative is not just about the death of John O'Keefe. The part of that alleged false narrative is the cover-up and conspiracy side of things that necessarily came after Mr. O'Keefe died. So it's inaccurate to say that we can capture anything relevant to this case by stopping on January 29th, 2022 or thereabouts. Secondly, as we're all aware, this is a third-party subpoena. At a certain point, a third party is not in a position with standing to argue about specifics of relevance. They have standing to argue about burden and undue burden on a third party, and we recognize that, and that's why we made changes. But a relevance objection like this is misplaced at this point.
That's right. A third party's argument is scope and burden some requests. It's not relevance. You can't argue or strategize for another party to the case. Like, relevance is relative to the claimant and the respondent, the plaintiff and the defendant. Third parties don't know what's relevant. They have no idea because they're not strategizing on the case. They're not in the case, supposedly, They're supposed to be hopefully witnesses, people who can testify to facts or so forth. But yeah. All right, Jackson. So where is Chloe? Okay, so does Colin own a cat or a dog, or does Reed own a cat or a dog? Like, where's the animal that caused the injuries?
We are entitled to put document requests in a subpoena that are reasonably intended to gather relevant topics. I think a term that relates to communications about Karen Reed and about John O'Keefe is well within that scope, as Rule 26 uses the phrase relevance.
Europe river cruising, 13 days, 2.
We did it again. Sorry, peeps.
Trying to get the last word, just a couple of things I wanted to add.
You got all afternoon.
First, if what she's claiming is that there was a grand conspiracy and a cover-up, okay? The date range we have proposed, to the extent there were any communications in furtherance of this conspiracy and cover-up, would more than adequately capture them. We're proposing a 3.5 year period. And so if, as Ms. Reed apparently purports to believe, there was a grand conspiracy that was occurring in 2022 and 2023, and there were communications about the circumstances of Mr. O'Keefe's death at that time, and the fact that all these people, dozens and dozens of people apparently were conspiring, then those will be produced, in this case, under the subject matter that we have scoped here. I also just, on the relevancy thing, we cited authority in our brief, Your Honor, that the party propounding the discovery has the burden of showing some relevance. And so this is absolutely an issue that the court should have to decide when considering what is an appropriate scope here. Obviously, you don't have to decide what information and evidence may be admissible or not. That's not the issue. But the reason that inquiry about relevance exists and is important for the court to conduct is because otherwise parties would engage in fishing expeditions all the time, which I know this court doesn't want, we don't want, but which Ms. Reed seems to be seeking.
One example of something that would not be limited to the about circumstances of Mr. O'Keefe's death. There are allegations that Ms. Reed has made in multiple lawsuits, including this one, that certain of the individuals in the house deleted phones or deleted contents of phones or devices. That obviously happened well after Mr. O'Keefe's death. If there was a text, and I'm not saying it exists because we don't know if it does, but if there was a text between Mr. Albert and someone else who was in the house that said, get rid of your phone, that would be very, very, very relevant to the alleged false narrative claims and the conspiracy that Ms. Reed has alleged, and it would absolutely not be covered by the circumstances surrounding Mr. O'Keefe's death. There are plenty more, but I think that highlights the concern.
Mm-hmm.
So they say it's included, you say it isn't.
Well, they say generally it's included, but if it were included, if the answer was...
It's stated on the record of 2 periods that they're going to produce what you're looking for.
Right, but as your Honor's aware, it's not our job to give them the specific examples of documents that may exist in their client's possession, custody, or control. It's our obligation to give them a sufficiently limited amount that it doesn't impose an undue burden on them, but categories, and that's what we've given. They've taken those categories and significantly narrowed it. And I recognize that Mr. Maddie, and I believe Mr. Maddie, that the 2 examples that he's commented on today, he says would fall in their narrow, very narrow categories, and that's great. But I think there are tons of other things that would be very relevant that would fall well outside that, and I don't think that's proper.
Anything else?
No, thank you.
Anything else?
Not on this. I just wanted to briefly update you about a different motion. Are you?
Hey, Buck, do you want to jump in?
No, I'm sorry, just one other.
All right, stay seated.
I don't want to be well enough. I don't want to steal the $30 thunder. There is the outstanding issue, Your Honor, about Mr. Albert's availability for a deposition. I know we've started discussing the scope, and so I'm happy to discuss that whenever it makes sense for the court.
Go right ahead.
Okay. Your Honor, since last week, we have made inquiries of the United States Army at Fort Jackson. We've also done some research about how a deposition of an active duty service member would be arranged. And bottom line up front, Mr. Albert, as a trainee in the United States Army, is under the command and control of his commanding officer. And so if Ms. Reed wishes to take his deposition, yes, sir.
Just curious, did your research include a subpoena that already was served?
Well,
exactly.
You're right. So I guess the question you're raising is,
Exactly, Your Honor. Yes. See, this is why we love Judge G, right? He's saying, did your research include you looking into the fact that the subpoena was already served? So it's not just how do you take a deposition of a military active duty, I want to say veteran, but not veteran, someone who is active duty. In fact, it is the subpoena was served already, because otherwise then you would have to go through the military court for certain cases. And the honor is like, no, the judge is like, no. Did you look into what's going on here today? Yeah. And also we would like to know, did Colin Albert fill out the form, and did he write down that he in fact was a part of an active civil case? We would love to know that.
if Mr. Albert had been served with a subpoena, correct, prior to entering the military, and let's presume for a second that that subpoena remains valid, even though I know you know we take a different position, and he then enters the United States Army in the interim, the United States Army has custody of his person. And so if the deposition is going to take place after the date upon which it was originally scheduled, April 29th, I think, then the only way for that deposition to occur is with the consent of the United States Army. And there's a process for that. What would happen is Attorney Reed's counsel, Miss Reed's counsel, or we could help facilitate this process, would reach out to the staff judge advocate at Fort Jackson and let them know that there is a request for a non-party in civil litigation pending in Massachusetts to take Mr. Albert's deposition. And I've never done that before, so I don't know exactly how that process would play out, but I know that
I've never done that before. Okay, counselor, did you find someone who has? Have you looked it up? Did you even try to find an attorney who could answer that particular conundrum? And do you hear him say, oh, well, you know, he's still arguing the same things that they argued last week, and the judge is like, no, we're not playing that game. Just where is he? When is he? Not in the fall. He needs to appear like now. He's coming back with the same points of argument that they had last week.
that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that the process would definitely include the staff.
A JAG officer? Wait a minute. Why don't you talk to a JAG attorney? Wait a minute. What's a JAG? Hold on.
Deposition. And I've never done that before, so I don't know exactly how that process would play out. But I know that that would be the necessary first step. Now, I've called the staff judge advocate 4 times at Fort Jackson between last week and this morning. I've left 4 messages. I haven't heard back. I've also consulted with a colleague who's a former JAG officer with 2 combat deployments. She advised me that the process would definitely include the staff judge advocate at Fort Jackson, may also include the Army Litigation Division, which is the main legal component of the United States Army. And that process would just have to play out. But the reality is neither we nor Mr. Albert have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has.
Guess what, counselor? That's why your client is supposed to let the Army know when he is in litigation, because they will delay putting him in active duty or putting him in training because he has to fulfill his obligations to the court. So irritating.
We nor Mr. Albert
so irritating to hear the excuses.
Have any authority to present him for a deposition while he is in basic training. He's not given any leave. He's not given any visitation at Fort Jackson. He has.
Oh, I just want to be clear. A JAG officer is a licensed attorney to practice in the military. So it's a Judge Advocate General Officer is what JAG stands for. I just want to be sure.
Very limited access to telephone. His day starts at 4:30 in the morning, ends at 9 p.m., and it's entirely structured. And the basic combat training program is phased. So that phase 2 builds on phase 1, phase 3 builds on phase 2. This is a 10-week program, after which we understand he will be granted leave. And so what I asked counsel last week was, listen, if Judge Gilday were to permit, given the burden that forcing Mr. Albert to submit to a deposition while he's in basic training would impose, if Judge Gilday were to permit an enlargement of the scheduling order for the sole purpose of conducting this deposition after Mr. Albert completes basic training, and if the other defendants, if the other parties agreed to that, would you? And they said no. And I asked them why, and they said they had strategic reasons. And what it made me wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending, and why they didn't take his.
Wait. Who? This court officer right here is like, oh my God, you're talking in circles. He's like, don't tell him no, they're not going to listen to the judge. If he puts out a court order is a court order. So I think the military would take issue. They would come up with some kind of way to respond to a judge's order.
Wonder is why they hadn't taken his deposition in the many, many months during which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
Well, the answer to the.
Are you serious, counselor? Are you serious that another attorney in the military said, we are going to do what we want to do, how we want to do it. We're not going to just release him to the judge. And when you asked why, their response was, we don't get to tell you why. It's our prerogative. And then at the same time, they turn around and say, why didn't they just take his deposition before? We don't get to tell you why. It's the judge's prerogative. It's the defendant's prerogative. We take the depo when we take the depo. Get out of here.
In which this case has been pending, and why they didn't take his deposition when he actually sat for it 2 weeks ago.
Well, the answer to the latter question is they didn't have the documents, and they had said in their discussions with you that they wanted the documents before they took the deposition.
And they don't have the documents now, Judge. And so what I'm saying is,
give them the documents, counselor.
The burden that this would place on Mr. Albert, and the fact that he's already been.
Excuse me for interrupting.
What burden?
The burden is self-imposed.
Thank you.
Because it was a subpoena.
You have to clap for Judge G. He's like, hold up with your stupid statement. The reality is the burden is self-imposed, you guys. First of all, they went back and forth relative to the documents. They went back and forth relative to the deposition rescheduling date. But when they took it off calendar, Reed's attorney said, okay, so when can we reschedule, and when do you want to talk about these documents? They stopped talking about it. They stopped responding to Reed's counselor. So they had to put a motion to compel before the court because you guys stopped responding until all of a sudden in May, a few days beforehand, he only has 2 days to be available, and otherwise, therefore, he's never available again. Self-imposed infliction of stress and burden at this point. And I love this judge for saying, hold on, you're not going to keep floundering around in my court. Truth of the matter is your client did this to himself.
But The burden is self-imposed because there was a subpoena.
Mhm.
And as I've said a number of times, a subpoena has to mean something. And there was also some agreement between the attorneys. And the words and actions of an attorney need to mean something too.
Your Honor, let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I read that email.
You're not aware of any agreement. Then you shouldn't be here. If you are unfamiliar with this case, you should not be here. You're spewing things you don't know. That's a problem.
Let me just say a couple things in response. First of all, I am not aware of any agreement between attorneys. I read that email traffic. I was not the one negotiating this, but I read that email traffic. And that deposition was canceled. And if they want to take a deposition of him on a different date, they can issue a subpoena for a different date. But it is my understanding that there was no agreement. I also want to just say one thing in response to the idea that Mr. Albert has imposed a burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a
If he tells everybody, define the word everybody, because the Kieran Reed team did not find out until after they put a motion through. So he didn't tell everybody. I wonder if he told anybody. Let your co-counsel tell it. He didn't find out till like May 19th, May 20th, depending on what part of the coin he flipped. But between those 2 days, that's who he told. And they said work related. They didn't say Army, military related. They say work related. So he didn't tell everybody. Oh gosh, this is why it's hard when people come in the middle of a conversation and they don't know what they're talking about, and they try to argue what everybody's talking about, but they have no idea what the subject really is. They're just talking out of both holes of their body.
burden on himself. If he is told that his deposition is being canceled, and then he alerts everybody to the fact that he's decided to enlist in the United States Army to serve his country, and tells everybody that he's going to be available for a deposition in a compressed period of time, and one party decides not to take advantage of that, and then he enlists and subjects himself to basic training. And the idea is that he was supposed to organize his life choices as a non-party witness around when Miss Reed might ultimately decide to take his deposition. I don't think it's fair to suggest that he's imposed this burden on himself. He's undertaking a burden to serve our country, made himself available for a deposition, and now all we're saying is, under these circumstances, wouldn't it make sense to conduct this particular deposition when the young man has completed his basic training, and after which we've resolved all these issues about documents?
Guys, you see this?
You gotta get out of here with that. You gotta get out of here with that. That is stupid. It's annoyingly stupid. Rosenberg, save us from this idiot.
You can read the emails yourself. I'm the one who wrote it. It said the deposition will be rescheduled when we resolve the pending dispute over the documents. Mr. Maddie points out we still don't have the documents. That's because they still haven't agreed to produce the documents, and we need to be back here with Your Honor for a second hearing to get what we believe is a significantly narrowed scope, which we proposed last week after Your Honor provided some feedback on the initial scope. Also, subpoena is not a request. Mr. Maddie said a request that he be deposed. It's not a request. It's a court order. The case law is clear. A subpoena is a court order. And obviously, we're not looking, as I've said, to impose an unfair burden. We recognize that the service didn't happen in time and immediately said, yeah, that's too tight. We will reschedule it. To now argue that by saying we will reschedule it, which is exactly what the email says, that we canceled the deposition and rendered the subpoena ineffective is, I think, absurd. And it flies in the face of the obligation that a party serving a subpoena has, as Your Honor pointed out, to work with the recipient in order to do it in an efficient way and not impose an undue burden. I also haven't heard any of this.
That's such a great argument. Rosenberg is saying we rescheduled the deposition to curtail an undue burden upon Colin Albert of having to sit down for 2 depositions. There is such a craziness. The first deposition without documents would be kind of haphazard. It'd be some information, but it'd be haphazard. Whereas the second deposition with documents would be more informative and be all inclusive, right? So they decided instead of doing 2 separate depots, let's do 1 depot with documents. Let's work this document thing out. So they worked hard to avoid an undue burden to Albert. And Colin Albert and his attorneys, seemingly, in my opinion, have taken advantage of that and played, hide the ball and whatever else. And now they're saying, well, it's unduly burdensome for us to actually do discovery that we're going to have to do no matter if we do it now or later. It's all important to all the claims. But not this claim. Is ridiculous. It's not unduly burdensome. And, we can't talk to him because he's wherever. And here's another problem. To say that you're unable to speak to him, your other co-counsel already said You have an hour to talk to him on Saturday. So you had an hour on the 20th. June 20th, what in that hour, what conversation did you have? Did you talk to his sergeant or, his superior officer? Did you no, you decided to call around on the main switch to find out if they can find one Colin Albert out of 375 billion active servicemen and women. They're going to find one person that you don't have a clarity as to where he's located, because one minute you say he's in basic training, the next minute you say he's active duty, and then you say he's in a 3-week class session. You're more confused than I am about the military. Okay, yeah, you don't know. But you had an hour on Saturday. What was that convo? To be a fly on the wall. That means client attorney privileged conversation. So obviously that's not up for discussion. But did you in fact talk to his sergeant or his commanding officer who was enlisting him? Did you talk to them? Or did you only just take 1 hour to talk to Colin and say, "Oh, don't worry. We'll go back on the hearing on Monday, and we'll just tell the judge you can't appear"?
The recipient in order to do it in an efficient way and not impose an undue burden. I also haven't heard any of this until right now. We've been conferring. I heard that it's difficult, but the specifics of the steps that they've been trying to take, we haven't heard. I would have a couple questions. One, was Mr. Albert asked to identify this proceeding and the subpoena that he had received when he enlisted in the military? If he was, does that impact his ability to come back to Massachusetts to appear pursuant to the subpoena that was issued in this case? At the end of the day, everyone here, I think, respects a decision to serve our country, but the timing of this is extremely relevant. We served the deposition, the subpoena. We had the back and forth where we said we would reschedule. We waited 3 weeks for a response on the documents. We got an email that said, in effect, he's available for the next 13 days and then he's gone. That's not appropriate, and that's not in compliance with a subpoena that's issued by counsel through this court. And if there's something we need to do in order to make it more possible, I'm more than willing to hear what we can do to help do that, but there's been no proposals, just he can't do that. And to address briefly this idea of extending the scheduling order, as Your Honor is aware, we've been working over the course of many months now with the understanding from Your Honor that is a hard deadline, and we need to do everything we can to get everything done in that deadline. And we've made tons of decisions in reliance on that. You've effectively kept us to that. We've got depositions, many this week that we're taking. Plaintiffs have taken a number. Things are moving forward. It'd be completely unfair for us to now have the deposition that we noticed early on in the schedule be put way back, in fact, after the deadline that we've all been operating under.
Your Honor, I don't understand any prejudice to misread.
We know you don't understand. You have very limited understanding compared to most of the people on YouTube. We're very clear on your lack of understanding. I really liked the fact that Rosenberg threw it out there. Well, what did he put on his application? However, I don't hear an actual response to that. We're just relevance.
Or her counsel for taking this deposition 3 weeks after the August 17th deadline. I'm not understanding what the prejudice might be. I do understand and respect the need for court-ordered deadline.
You don't understand what the prejudice may be? Well, maybe the prejudice is Colin Albert says that, what's her name? Allie McCabe, didn't pick him up, or she took him to the high school and didn't drop him off at school. Drop him off at home. That the reason why her Life 360 says she was by the school is because that's where she actually dropped him off. And he got out and stayed, played basketball before he went home, and then he went home. Then it's relevant, because then guess what? Now we need to talk to Nicole Albert, who says that he came in and gave her a hug and a kiss and told her good night with all his drunken breath on her, whatever. So it's relevant because once you have a deposition of one particular witness, it may affect the way you ask questions of another. And it's none of your business. And he's talking about relevance of timing, obviously. It's none of your business as to if they want to take him, if they need his deposition now before the deadline or otherwise, because the judge has said the deadline is the deadline and we're going to respect my court. And beyond that, it's none of your business because it's not your case, right? You're a non-party. So get over yourself.
To misread or her counsel for taking this deposition 3 weeks after the August 17th deadline. I'm not understanding what the prejudice might be. I do understand and respect the need for court-ordered deadlines. Here, I don't know what their strategy is. I don't know either. But that being said, whatever their strategy.
That's right. Even the judge doesn't know what their strategy is. And counselor, guess what? You don't get to tell them what their strategy is.
Here,
I don't know what their strategy is. I don't know either.
that being said, whatever their strategy was, apparently meant that they weren't going to take his deposition in the first year in which this case was pending, and then decided that they would take it. And then when there was a dispute about documents,
Is that the same time?
our position is they canceled it. Our position is that there's not a valid subpoena to be enforced right now. However, given the importance of working collaboratively with counsel, we are going to continue to do that. And if the court tells us that we need to find a way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it.
Why haven't you done that already? Didn't you just say you did that already? I could have sworn you gave this really long soliloquy of talking to the JAG officer who has nothing to do with this particular matter or even this particular branch of government that happened to serve the country at some other place and get an understanding from them as to what the procedure may or may not be. And then you called around town and you know, you talked 4 different times to the operator down at the Pentagon. I don't know. So, you know, what's it called now? Defensive war or war of defense, whatever. You talk to them. Okay. So didn't you say you had investigated this and looked it up? So now you don't know. You still don't know. You did or you didn't? I don't understand.
A way to pull Colin Albert out of basic training, we will go ahead and see what that process is and pursue it. But I don't think that's fair to him. I really don't. And I don't think Attorney
Fair to him. I'm sorry. Sir, your client was aware that he had a deposition subpoena sent to him. If you fail to advise your client appropriately, that sounds like malpractice on your client's behalf, that you failed your client. That's what's unfair to him, that you let him think that the subpoena was non-active. You let him think that the deposition was canceled and not trying to be rescheduled. You let him think his obligations were fulfilled when he sat down with Diller. That is a malpractice concern of yours because you were in error. So fairness to him is for counsel to represent him lawfully and appropriately and to inform him accurately. You failed your client.
That's fair to him. When we could take this deposition just a few weeks after, one witness, then he will have finished basic combat training. He will be on leave. You won't need to go through this process, which I'm just now learning about trying to persuade the United States Army that they should release a witness for a civil proceeding in Massachusetts when they don't even let him have his phone. However, if that's the course of action that the court wants us to take, we will work with Attorney Rosenberg to try to facilitate that. I just think it's highly unfair this year.
Oh, Your Honor, ask him how does he talk to his client on Saturdays for an hour? How does that happen? And what happened on June 20th?
To be clear, I do think I understand the burden it imposes, but as Your Honor said, it's a self-imposed burden that he knew he had the subpoena. He decided to enlist when he decided to enlist, and that resulted in him being unavailable less than 2 weeks after he could give the other side notice. So this is not someone who was already enlisted, who we tried to serve a subpoena or say served a subpoena when someone was back on leave, and then they ended up back under the control of the military. That's not what happened here. The timing is set out very clearly in the communications that are part of the record. And I think not only is it fair under the circumstances, I think it's required, and I would ask the court to order Mr. Albert's counsel to present him. And I represent to you that we will work with them and do what we need to do to assist that. Well, first of all, he was available for a deposition. He sat for a deposition in this case. And secondly, Judge, in all deference, if you order us to make efforts to arrange his appearance at a deposition, we will do that. But we do not have authority to produce him on our own. The United States military does.
I think it would be a great idea if you found out more.
We'll continue to work on that. I was hoping they would take my calls. They didn't. But we will continue to work to find out more about how that process might play out. I'm confident that the initial step would be reaching the staff judge advocate and informing them person to person of the status of the situation. I've left that information in my messages, but I haven't been able to reach anybody, and I will continue to do that if that's the court's recommendation.
You might not want to use the words, the other side canceled the deposition. Couch it in terms that it's disputed.
It is disputed, and that's our position. Thank you, Judge.
Okay, thank you.
Your Honor, can I briefly just update you on that other motion I was talking about? It wasn't that.
All right, you asked at the end of the last hearing what other motions are coming to you. There's one that relates to Mr. Matt. Well, I think Mr. Matt is representing
Then, but the other individuals.
He's not jumping up.
Yeah, I know. I don't want. Well, he's representing some of them in the defamation case. Yeah, I don't want to take too many liberties with the courts. I was trying to be careful, but we've got deposition notices and a motion to compel for Brian Higgins. Excuse me, not Brian Higgins. Brian Albert, Nicole Albert, Jennifer McCabe, Matt McCabe, that's coming to you very shortly. We discussed that earlier. Separately, we had a deposition scheduled of Lieutenant Brian Tully of the Mass State Police. We served Lieutenant Tully with a subpoena May 5th, and it sought documents June 1st and June 11th, so we did a better job with the service. His counsel asked to reschedule for July 8th. We rescheduled, and then the day after our hearing last week here, we got a motion to quash saying, asking the court to say he doesn't have to show up at all, doesn't have to produce any documents. It came out of the blue. They didn't confer with us. We don't know why there would be a change when we accommodated the date. So that we served an opposition to that motion the same day we got it, which was last Thursday. And we urged them to please file it with this court as soon as we can. I don't believe that's happened based on the docket, but I just wanted to give you a heads up that that is on its way.
They know we're in a juicy space. Okay, we don't care about whatever that is.
The four parties you talk about, there's a motion ready to be filed?
Yeah, I believe the opposition is due today.
It's my understanding that we'll be serving our opposition, or that those individuals to whom the motion is directed will be serving their opposition today, I believe.
And we'll aim to file it tomorrow.
I do represent a number of them in the defamation case, Your Honor. It's the same situation as we have with Mr. Albert here. I'm not admitted to represent them here.
You're probably going to be here on their behalf.
Well, Mr. Tuxbury's still on vacation. I probably will, but yeah. With your permission, of course.
When would you like to do that?
Wait, so Jim is on vacation? I know he's like so glad not to be in this particular hearing.
Before we jump to that, the plaintiffs have two forthcoming motions that, contrary to public belief, I have other cases that have depositions too. Personally, I don't, just for the record, to be clear, I don't want to convince the U.S. Army of anything. But the plaintiffs have forthcoming motions to compel Aidan Kearney, as well as further answers to interrogatories from Miss Reed. I believe the opposition was just served the end of last week. I've been out of the office Friday and today, so I believe that both will be filed either tomorrow or Wednesday.
He's so funny. This is the attorney who's like, it's better to be quiet amongst this crew. It's like, I don't speak unless spoken to.
When would you like to do those?
I assume we're going to have four now. I think we're going to have those two. We're going to have ours as soon as Lieutenant Tully's counsel files his 9A package, and then our motion. So I'd say as soon as we can, because.
Or I was going to suggest right after the 4th of July holiday, possibly. We have a robust deposition calendar, as Your Honor's aware.
I don't know the court schedule. We could do July 2nd to get it, because Lieutenant Tully's deposition is supposed to be the 8th. We've got that set aside. Everyone has that set aside, I think.
I believe we're scheduled for a 30-6 on the 2nd.
I think that's the one that you just emailed and said. They asked
so we were double booked that day.
Okay.
So the 30-6 of C.F. McCarthy's.
How about the 6th? It's the Monday after. I don't think we have a depot.
I'm not aware of anything currently scheduled for the 6th.
This is my only case, so don't worry about it.
Just like all of us here.
This is the only case. And all of his claims, huh?
We don't have a trial that today. Okay.
Okay,
So why don't we say 2:00 on the 6th?
Would that be for the first motion Attorney Rosenberg described as well?
Whatever you got out there, let's get it in here.
Okay, all right.
Yeah, we'll file it as soon as.
What I'd like to do, Judge, if you don't mind, if we could tentatively set that as the date, and then I could consult with co-counsel and just make sure that works for them. And if for some reason there's an issue, I could confer with Attorney Rosenberg and everybody else. Would that be all right?
We were seeing that sidebar for a second.
Sure. Come on up.
no, not another sidebar. Yay, thanks, Trial Channel. Thanks so much.
Yeah, for the motion hearing.
Still have our status on Friday at 9:45.
At Your Honor's direction, the World Cup fan inside of me put that aside and worked through the weekend to update the court on the pending motion to compel documents with Ms. Reed. Would you like to hear that?
What?
So for our conversation last week, there was a link sent to me while Attorney Fell and I were conducting a deposition prior to the hearing here on Wednesday, the 17th. Over the weekend, I was able to access that link and confirm that there were responsive documents included. The plaintiffs have some concerns to date. We have submitted 53 requests for documents to Ms. Reed. 34 of those were met with objections for attorney-client privilege and work product. I do not have any privilege logs to date. nor do I have what I believe to be compliance with Superior Court Rule 30A that states the documents that are being withheld due to that specific objection. That being said, Ms. Reed is scheduled to offer deposition testimony on Wednesday of this week, less than 48 hours from now, the first testimony she's given to date. And my clients are at an extreme disadvantage because I anticipate forthcoming motion practice as to those objections, but without knowing what's withheld, I can't pursue the additional motion practice to put in front of this court to determine whether or not that privilege upholds.
Okay, so he said a lot. Basically, Karen Reed is sitting for depo on Wednesday, the 24th of June, and he on the 22nd is stating that they still have deficiencies within the production, the document production that they were working on last hearing on Thursday. And he's stating that they don't have the log. And the log is basically like a table that shows, or that not shows, but actually describes, this is what we're holding back. You know, it's an email chain dated XYZ between counsel and Ms. Reed. It is, you know, it is attorney work client privilege. It's attorney client privilege, or you may have, here is a memorandum by Attorney Rosenberg or by Jackson to Attorney Rosenberg, and then you categorize it as attorney work product. And so those particular things are not attached, but there is description as to why they're being held in as attorney-client privilege and what they are, like they're a text message, they're an email, they're a sheet of paper, they're a memo, whatever it is. And then he also stated that there was something else he didn't have, but basically it's regarding the documents. Half have been produced, the other half have been objected to, and he doesn't have the tables to confer, to determine if they need to confer further on them. And since it's 2 days out, he thinks that that's not a sufficient amount of time. And his motion practice statement is motion to compel, having a hearing, having objections and replies, and going after the judge's intervention. That's motion practice. All right.
This issue, Mr. Buck and I discussed right for the first time at the beginning of the last hearing last week on Thursday. As I told Mr. Buck, we agree we're going to get them the information that's required by Rule 38. We're working on it right now. We're already working on it when Mr. Buck asked me first on Thursday, and we will get it to them. This is the first I'm hearing of an issue tied to the upcoming deposition. I will talk to the people that are doing it right now and try to get that to them before that deposition. But they have, obviously, they'll decide how to handle that at their deposition.
Maybe remind them that if you're going to make such an objection, you're supposed to provide the privilege line, not something you work on after you make the objection.
Okay, so that's a good point. The judge is saying that when you make an objection to production, you do so stating that you object with a privilege log, and the log is what we just talked about. Attorney work product privilege or attorney client privilege, whatever that is.
We identified the objection, and then once we've withheld the documents in the production that just completed, we are providing the information, but it's taken.
This is not the collective view because you get someone else you can consult with, but they obviously had the documents in front of them
When they
in
were
order for them to
answering.
make the objection, right? So the next logical step would have been, let's give them a privilege line.
Well,
Can you imagine working for Judge G? It's like, I need efficiency at all times.
not necessarily in front of them when they made the objection, because the objection is made in the written responses. You're not looking at the documents at the same time. But I understand, Your Honor. We're not fighting that.
We did have a conversation about it, but
Rosenberg, don't argue that. Come now, you know what he's saying makes sense. He's saying in order for you to determine that the request is objectionable based upon the documents that it produces, you see the document in and of itself. So create the privilege log at that time, and then go to the interrogatory or the request for production and say, document 333 is privileged because of, attorney work product privilege or whatever, and have the privilege log in hand at the same time. Unfortunately, though, some of what Rosenberg is talking about, it's not one person doing one thing. That's the difference. So whoever is pulling the documents should be tasked with creating the privilege log, which is typically the paralegal. The attorney will flag it, the paralegal will pull it, and they should do the privilege log. The secretary will double check, ensure that the documents that are in the privilege log are not in fact a part of the production. Then they will run it, get it bait stamped, and attach it to the delivery. But, you know, every office works differently.
At the same time, but I understand, Your Honor, we're not fighting that.
Yeah, we did have a conversation about it, but to Your Honor's point, the initial responses to my first request were served on me in October. I don't have a privilege log for that request either.
Yeah, Attorney Rosenberg, it's similar to the last discussion on the motion to compel. You collectively suggested the issue was moot because you had filed a written response, but you hadn't produced the document. So now you've taken care of it. But all that just engenders delay.
I agree, but I would say the reason that those keep coming before you is, like right now, we haven't had a conversation yet under Rule 9C about the timing of when we're going to give them the privilege log. It was raised for the first time at the beginning of last Thursday's hearing, and my response was, you're right, we're working on it, we're going to get it to you. This is supposed to happen, frankly, outside of the court. This is supposed to say, we need it by Tuesday because their deposition is out on Wednesday, and let me
Well, yeah, and you're supposed to know that they have a depo on Wednesday too.
outside of the court. This is supposed to say, we need it by Tuesday because their deposition is out on Wednesday, and let me respond.
But I think what Attorney Buck is saying is we should have gotten it a long time ago.
And I'm by no means here claiming nefarious action or anything of the sort. I'm stating facts because Superior Court Rule 30A states that where a privilege log is required, the log shall be served with the supplemental response unless the requesting party waives entitlement to the log or agrees to a later date for service.
I'm not suggesting nefarious actions by anyone. I'm just suggesting actions that result in delays. More need to come in front of me and talk about this stuff.
I understand that, Your Honor. I'm just saying, I think we didn't need to come before you to talk about it, frankly. And the supplemental response is the supplemental written response in Rule 38, which comes after the documents are produced. So I really don't think this is something we need to quibble with before Your Honor. We will get it.
Translation, Your Honor, they're complaining in front of you for no reason. They're trying to just get us in trouble.
Do them as quickly as we can, and if we can do it before Wednesday's deposition, we will do that.
Probably not going to complete the deposition in a day anyways, right?
I don't anticipate that the likelihood of that is very high.
Certainly with other parties too.
Yeah. I just wanted to confirm that you had requested that I review the link, and I've done that. And as we said here, my preliminary review shows that I received responsive documents to 3 of my 16 requests. So I anticipate further motion practice and at a later date. But you requested that I look at everything in a day.
All right. We'll see everyone on Zoom on Friday morning at 9:45.
Looking forward to it.
Not me, Your Honor, right?
We'll admit you if you want.
Yeah.
Thank you.
Thank you, Your Honor.
Okay, so thank you to the trial channel. Yes, the trial channel. We have to find, I got to find the link so I can put it in the chat. Let me find this link. Is this the link to the trial channel? Listen, when you get over there to the trial channel, give them all the love, okay? Let's see if I can put it here. Go ahead and like and subscribe. Put a positive comment. Everybody says put a comment. Put a positive comment and let them know how much you appreciate the fact that they got us the hearing. We were like all day long. Look at my hair is all over the place. You guys drove me crazy. Well, not you. but Boston News drove me crazy all day long. I'm like, we got to have this hearing. We got to have this hearing. I don't necessarily have this complete specifics as to the delay in and of itself. But what was reported in the afternoon, the early afternoon, was that the judge did not want it live streamed or, live. So it was a recording that had to be updated and uploaded. And I don't know how the trial channel got the recording, but they work miracles over there. So all the best and a whole bunch of thanks to them for working their miracles. Really appreciate that. So what did we learn? We learned that nobody wants to be deposed. It doesn't work like that, crew. It does not work that way. This is the O'Keefe case. So O'Keefe is the family. The O'Keefe family are the plaintiffs in this matter. But, as a result of the O'Keefe bringing the matter, the family, everyone else gets to be asked questions and you get to be deposed because you're either witnesses of, direct dealings or you heard about what happened. You were involved in some way of that nature. And so you get to come and be deposed. So Sorry, guys. I'm trying to respond to one of these clients. All right, sorry. I had to get that out real quick. So he gets to be deposed. Colin Albert, Nicole Albert, Brian Albert, Brian Tully doesn't want to be. Come on now. So we will see what happens. We have to come back to court, but we finally got into this court. So thankfully, we now know what happened. That is the full hearing. Replay crew, love you. Thank you so much. Hope you enjoyed it. We finally got the hearing. Talk to you later. Lyric Armstrong, your real estate agent and advocate. Have a great one.